Hello guys, welcome back to our video update. It's Sade here. Today's video is going to discuss how to make sure you are not personally liable for your business debts or obligations. So how do you go about making sure everything is covered? I'll go over the concept of corporate privilege or corporate bail, as people call it, and then I'll discuss how to avoid having that corporate bail pierce when creditors or plaintiffs are trying to go after the business for some sort of complaint that they have. So typically most people start a business small, and then once the business is getting more and more successful, they go ahead and create a company to make everything more formal and to make it easier to run the business, and as well as to protect them personally from liability. So this is all great. And so where does this tend to go wrong? Where it goes wrong is that in all the states, including the state of Texas where I am, the state requires all for-profit businesses to file certain reports. So once you form that company, you get a certificate of formation, and then you go ahead and file an initial report. And then the state requires all companies to file annual reports or public information reports, and also to pay certain taxes. So if those requirements are not followed, the state will forfeit the right to conduct and transact business in that state. And that is one way of losing the corporate privileges that I mentioned. And so when you're starting your business, you do everything right and then continue to do everything right. The state would normally send you a notice of intent to forfeit the company. So you'll have a chance to fix things. And if they're about to forfeit the company, you have about 120 days to go ahead and take care of anything that needs to be taken care of, like filing the right reports and paying the taxes that they claim you owe. And make sure you're checking in once a year to see where you are, just in case you missed some correspondence from the Secretary of State. So that would be my suggestion for that part. Once that happens, if there's a forfeiture, the law says that the company loses its right to sue in that state or to defend against any lawsuits. And therefore, if the company cannot be sued and the company cannot sue, typically if a plaintiff will go forward and sue that company because the company is not able to defend itself, then the officers and directors of that company and the owners, shareholders, are exposed to liability if there's proof of liability in that case. So that is one way that the corporate bail would be pierced, for instance. The other instances in which the corporate bail will be pierced is if it's found that there is intent to defraud, or there's some sort of fraud on the part of the owners or the officers. And so then the plaintiff can then sue the company and also sue the officers or owners in their individual capacities. And in order to do that, there has to be some level of fraud shown. And typically, the argument will be that the defendant created that company as a sham. So they will say that the defendant created the company as a sham to perpetrate fraud. And then the second thing that people typically say is that the company was created to avoid a legal obligation. And then sometimes that the company was created solely to circumvent a certain statute. For instance, I had a case where somebody created a company, which was a shell company really, to try to avoid the homestead laws here in Texas. So they created a company to transfer the property into, just so that the type of loan that the person was able to get did not involve or trigger any of the home equity laws, which are very, very strict here in Texas. So that was really considered to be a sham transfer, a sham creation of the company just for the purpose of circumventing the home equity laws in Texas. And then the other thing that people could say is that the company was created solely as a tool or a conduit to the defendant or a parent company. So what does that mean? That means that that second company was created solely to serve the first one. And when that happens, the courts will look at a lot of factors. It's called the alter ego argument, really, to see whether that second company is really being run by the parent and that their operations are commingled. Their funds might be commingled. The parent company might be paying the employees of the subsidiary. And also, they might share common officers and directors, and there's really not a clear distinction between the two so that the lines are blurred. When that happens, the courts tend to allow the veil to be pierced because the subsidiary is not independent of the parent. The other instance is if the subsidiary company or the company is undercapitalized. It's undercapitalized for the type of business that it is. So depending on the business, you might not need a lot of capital. But for instance, the home warranty businesses out there, they're required to carry a certain amount of reserve, to hold certain amount of funds in reserve because of the types of companies that they are. They collect monthly payments from homeowners and they promise to come and do certain repairs. So the state requires them to carry a certain amount of insurance and also to carry a certain amount of reserve funds for purposes of running those businesses. So if they're undercapitalized, then that means that their corporate privileges have been abused, and the courts tend to pierce the corporate veil for those instances. And so those are the kinds of things that the courts will look at to be able to figure out should we or should we not pierce the corporate veil, so that when you hear that, that's what people are really arguing about, that the owners or the directors, the officers or the employees, that they have abused those corporate privileges that typically shield them from personal liability for actions of the company. Because the company, remember, is regarded as a separate entity, as a distinct entity, separate from the owners and the employees and the directors and officers. So what does all of that mean to you? It means that you have to be very careful when you're running the business. You have to be very careful to make sure you're on top of all the reports and the taxes that need to be paid for the business. And you also want to make sure that you remove all officers that are no longer active with the company. You want to make sure that you remove yourself as an officer or an owner from the actual records of the state, the Secretary of State, so that you are not responsible for any actions or bad actions of another officer that's still running the company. Okay, so you want to remove your name officially from the record anytime you leave a business or a company. Don't trust the other party to do it. Make sure you file those documents and check to make sure that the Secretary of State received them. The other thing you want to do when you wrap up the affairs of the business is to do it officially. File the right documents. They're all out there, these days. So get a lawyer involved if you think that you need a lawyer to help you with that. But wrap up the business the right way, because if you don't wrap up the business the right way, then you expose yourself as the owner or officer to the debts and obligations of the company, if there are any. So typically, how do the limited liability companies work? The Limited Liability Company Act here in Texas does shield the members and owners typically from the debts and obligations of the LLC, unless the regulations of that LLC says otherwise. Okay, so you could still change things inside the regulations in regards to the owners, the managers, and the members. And then you could also lose that protection similarly to how a corporation works, the way that the officers, the directors, and the shareholders could lose the corporate privileges to allow a plaintiff to pierce the corporate veil, you could also be exposed in that way with an LLC, even though it's not typical. The courts are very hesitant to pierce the corporate veil, but they will if they see blatant fraud, or if they see a lot of mishandling of the affairs of the corporation. So there's an abuse of the corporate privileges, and or if they see that the owners left the company without any resources, that typically if a company can cover its own debts, they don't pierce the corporate veil. So hopefully this video has been helpful to you. I just thought I'll share that because we get a lot of questions and a lot of litigation surrounding these topics. And if you like the video, give us a thumbs up. And if you like the channel, make sure to subscribe, and we'll be putting out more videos in future. So thanks for watching. As always, let us know what else you'd like us to cover, and we'll do that. And we'll talk to you next time.